Good afternoon. I said good afternoon. Hi everyone, welcome to today. My name is Cynthia Jones. I am here on behalf of our local Federal Bar Association for the Western District of Washington. I have a few housekeeping announcements and a few introductory remarks. But before I do, I would like you to hear from our incoming FBA President, Robert Flanaugh. Robert, would you come up for a moment?
Again, welcome and thank you very much for coming. You know, the good thing about the Northwest is there's no racism. There's no segregation. There have never been any issues. We're kind of wondering why you're here, sir, because we get it all solved. Let me tell you a quick story about my parents. My parents met back in the late 50s. My father was the black person in his dorm at University of Washington. My mom was the black person at the University of Washington for her dorm. They had a mixer, and go figure. That's what happened. So around 1963, they got married. And my dad decided to go to dental school, and my mom became a teacher. She got a job in Kirkland. And most of you know where that is, of course. And they tried to figure out a place of where to live, where to rent. My mom would get in the newspapers. She would find out a place that was open. She would call. She would get there. You know what? The place would be rented out. And then she'd go to another place in Kirkland. And you know what? The place was rented out again. And she found out there's no places that she could rent. And it got to the point where my mom and dad had to rent from the basement of a white school teacher in the school. And my mom was the only black teacher in that school in Kirkland, maybe in the school district. And people protested. And it was a long fight for her to keep her job, but she did. Now, she ended up doing quite well as a school teacher. She ended up having her own TV show, and Bill Nye, the science guy, actually bought the rights. So she did quite well. My father ended up doing well, ended up being president of the Board of Regents at the University of Washington, and was the first black person to graduate from the dental school. But even today, there are things back then that affect my dad. There was a person named Edwin Pratt, who some of you may know from the Seattle Urban League. And back in 1969, he was in his house. He was out in Shoreline. It was nighttime, and there was snow hitting the windows. And those people could see in the house. Pratt could not. He went outside to see what was going on, and they killed him, shot him. This is Shoreline, 1969. To this day, my dad, as well as he's done, still at night will not have his windows open and won't have the blinds open, even to this day. So, Mr. Rothstein, we need to seal it. I'm so happy that you're here to kind of talk to us about racism and segregation. Of course, the example I gave was not government segregation, but still about, even here in the Northwest, what people had to endure. So I'm the incoming president of the Federal Bar Association. And I'll tell you, of course, it gets a little confusing because there's the National Federal Bar Association. But you know us Northwest people, we're kind of independent. So in the Western District of Washington and Eastern District of Washington, those are the only two districts in the nation that have their own standalone Federal Bar Association. So you should be proud of that. And the reason why was back in 1977, people wanted things local and not just national because they felt they were ignored. Judge McGovern and a few other attorneys got together, and along with eventually 38 people, including Ninth Circuit Judge Betty Fletcher and U.S. District Court William Dwyer, started the group. And that's why we've been around. We now have 700 members, including the past presidents of Ninth Circuit Judges Margaret McCune and Ninth Circuit Judge Richard Tallman. We have 15 committees, and we help people. First of all, we help lawyers, and we have CLEs. There's a great CLE like Cynthia Jones and the others are putting on today that we do, like the Power Act, bench bar CLEs. We have the Litigation Academy where new lawyers learn how to try cases in federal court. Because it'd be intimidating talking for Judge Lasnik and making rulings, as he makes rulings and you having to talk. But what I really like is that we help people. I know as attorneys, we're people, but like real people. We have a pro bono panel to help pro se litigants. We helped and worked on the DREAM program. It's a federal drug court program. We have the Federal Civil Rights Legal Clinic, which helps marginalized populations in both Seattle and Tacoma. We have a summer diversity externship program, which helps law students with diverse perspectives, working with district court judges. We have a mentoring program. We have, get this, IP law. Students in high school who want to learn about intellectual property, and they make it fun. See, I'm a criminal lawyer, so I have my own bias, but they make it fun, they love it. We have a high school essay contest. We have a Constitution Day where federal judges talk to fifth graders about Constitution, and then they have a mock trial. And then my favorite, which is the Youth Law Day, which I know I see Judge Jones here. We've been doing that for years, and I was heavily involved in that, where diverse kids in both Seattle and South King County meet with federal agencies, and they have a mock trial. These are programs helping people. So, if you're not a member, my little quick page is join and talk to us about it. You have the opportunity to, one, come to CLEs like this that are sold out, and you have many opportunities to help real people. So, on behalf of Federal Bar, Western District of Washington, the standalone group, we welcome you. Thank you.
Thank you, Robert. So a couple of housekeeping items before we get started. First of all, I have some thank yous, and I want to first and foremost thank Tony Duck. Tony is standing in the back of the room. He is the chief of everything IT in court. He makes this courthouse run. He helps us with our virtual piece of this event as well today. So for those of you across the Ninth Circuit streaming in today, I would like to just let you know there will be at the 40-minute mark a verification code so that you can claim your CLE credit, and we will process that for you, but we need the verification code from you for that. Judge Lasnik will be announcing that, and it's top secret for now. Also, when you walked in, for those of you in the room, there was a sign-in sheet. And if you want to claim your 90 minutes of ethics, DEI, CLE credit, make sure that you sign one of those sheets before you leave today so that we can register you for your CLE credit. There was also an evaluation form that you would have wanted to pick up on your way out. Make sure you fill those out and give those to us on your way out to our 3 volunteers. That helps us, your feedback helps us figure out what kind of programming our legal community would like to see. So if there are additional ideas that come out of today, please note that on your evaluation form. I would also like to thank those 3 volunteers. We have Roger Townsend in the back of the room. You met him coming in. Roger is an amazing human being in that he's here today to help with his dual role. So right now he serves as the chair of the Lawyer Representative Coordinating Committee, which is a huge job. It's a chair that is across the Ninth Circuit of every lawyer rep in each district in this entire circuit. And then Chief Judge Murguia of the Ninth Circuit, in her wisdom, also appointed him as the chair of the programs for the Conference Executive Committee, which plans all of the programs for the Ninth Circuit judges, district judges, bankruptcy, magistrate, etc. every year. And when I made a call out for volunteers, we started, Richard and I talking about this program today. I thought I'd be sitting there with a few people registering you to come in, and when we got the robust response that we did, Roger needed some help, and he signed up, and thank you, Roger, for your busy schedule and being here today. And also Lori Thornton, are you in the room or are you still at the table? Lori is a brand new Ninth Circuit lawyer rep, but no stranger to the Western District of Washington, and I thank Lori for being here. And then finally, my mentee, Cameron Powell, who just graduated Seattle University School of Law and passed the bar. Yay, Cameron. So one of those three people, please hand your evals at the end of the day to them. And then I also want to point out, we've got the verification code, we've got our thank yous, we've got our DEI credits, and for those of you online, I will be checking my cell phone. Our Tony Duck IT King has gotten me connected directly to the Zoom so that as your questions come in, Judge Lasnik will be entertaining questions with Mr. Rothstein towards the end of the program. We'll make sure that your questions get addressed at that time, but I will be monitoring those for you. And then last, before I bring up our Chief Judge to give his introductory remarks, I just want to acknowledge that this court and our Federal Bar Association recognize and acknowledges that we are gathered here today on the land of the Coast Salish peoples and the Duwamish tribe, and just to take a moment and reflect on location and that this is a welcoming space for everyone. And with that, it is my pleasure to formally kick off the program. Please welcome our Chief Judge of the Western District of Washington, David Estudillo.
Hey, welcome everyone. Good afternoon to all of you. And I'm very excited today for today's Fireside Chats with Judge Robert Lasnik and Richard Rothstein. I know Judge Lasnik will get into more of the background, so I might be stealing a little bit of his thunder here, but Richard Rothstein is the author of the book, The Color of Law, A Forgotten History of How Our Government Segregated America. It's published back in 2017. And he's also now the co-author of a new book called Just Action, How to Challenge Segregation Enacted Under the Color of Law. Also, Mr. Rothstein is a distinguished fellow of the Economic Policy Institute and senior fellow emeritus of the Thurgood Marshall Institute of the NAACP Legal Defense Fund. I also want to thank the Western District of Washington Federal Bar Association for coordinating today's Fireside Chat, and of course Judge Lasnik for being here today for moderating the discussion with Mr. Rothstein. And just as others have mentioned, there is a rich tradition with our local Federal Bar Association, which we hope to continue. They put on a lot of good programming and assist us with getting information out to the rest of the bar. So thank you to all the members, and especially the leadership, of course, that really facilitates that interaction between our bench and the Federal Bar Association, or members of the Federal Bar. I'll just say briefly, true equality and equity within our society are concepts that start with an individual's ability to meaningfully choose where and with whom they want to live. The history of housing and residential segregation in our country, including the governmental policies that assisted in promoting and maintaining such segregation, is a very important subject to study, to understand, and hopefully combat. So, Mr. Rothstein, on behalf of the Western District of Washington, I want to thank you for being here to discuss those issues with us, and hope you feel very welcomed here, and always are welcome to come back in the future, of course. So thank you. With that, I'm going to turn it over to Judge Lasnik, and ready to hear this discussion.
Thanks very much, Chief Judge Estudillo. One of the things I wanted to do in my 7 years as Chief Judge I never got around to, but I'll ask David to do, is, well, why do we have a separate bar association, and maybe we need a separate court? You know, why don't we just leave the rest of the United States courts and have our own little court? We'll go in with the Eastern District. I think that's fine, and I'll even allow some of the judges in the Nakamura building to review what we do, but, you know, let's take it to the next level, David. All right, well, Richard Rothstein and I have decided we're going to talk to each other in first names, so he's Richard and I'm Judge, right? And Richard is from Queens in New York, and he went to a public high school called Bayside. And the Bayside Commodores. Yeah, sure, right. Have you ever been a Commodore?
There was no football team on it. High school.
Yeah. But you also mentioned to me there were no black students at your high school when you were there, or none in your classes, right?
None that I ever met.
Yeah. But now the mayor of the city of New York, Eric Adams, is a graduate of Bayside High School. Did you know that?
No, I didn't.
Yeah, he is. Because I looked at famous alumni from Bayside. Mayor Adams is there. He's not. So we'll see if we can correct that going forward. But, you know, when you went to a public high school in New York City, whether you were Ruth Bader Ginsburg at James Madison High School in Brooklyn, or Bob Lasnik at Port Richmond High School on Staten Island, or Richard Rothstein at Bayside High School in Queens, you know, you were part of the community. And so you got to see what your community looked like. And it looked like a lot of white people. Maybe you had the diversity of a couple of Jews, a couple of Puerto Ricans, a lot of Italians, and a lot of Scandinavians. But that was it. And you knew that there were other people in your city and in your borough, but they didn't live where you lived. And we never questioned it at all. It was just something that was there. And when Richard wrote his book, The Color of Law, and it revealed that this was not an accident, that people were intentionally doing this, it came as a shock to many people who should not have been shocked by it. Because it wasn't done in the dark of night, in a back room, by hooded people. It was done by elected officials and appointed officials. Now, Richard, one of my legal scholar heroes is Bob Dylan. And he wrote in Hard Rain's Gonna Fall, the executioner's face is always well hidden. Who were the executioners of this policy that started during the Franklin Delano Roosevelt years with a vengeance to change, not to prolong segregation, but to change integrated communities into segregated communities?
Well, that's certainly part of the New Deal. I think you're referring to the public housing program. There was no public housing, civilian public housing before the New Deal. The federal government was never involved in it. The very first program of the New Deal was the Public Works Administration, which built the first public housing in this country. It was not for poor people. There were some low-income people admitted to public housing, but it was mainly for working families, middle-class families, who could afford housing, but in the Depression there was no housing available. So most of the public housing residents, when the Public Works Administration built the first public housing, were white. There were some African Americans always in segregated projects. The Public Housing Administration created separate projects for African Americans, separate projects for whites. I'm not talking about in the South, I'm talking about in the North. The great African American poet, novelist, Langston Hughes, talked in his autobiography how he grew up in an integrated downtown Cleveland neighborhood. It's not how we think of downtown Cleveland today. He said his best friend in high school was Polish. He said he dated a Jewish girl in high school. That's because he lived in a non-segregated neighborhood and went to a non-segregated high school. The Public Works Administration went into that neighborhood in downtown Cleveland and built two separate projects, one for African Americans, one for whites, creating a pattern of segregation that hadn't previously existed. Now, I'm not suggesting that every northern neighborhood was not segregated. Of course, there was lots of informal segregation. But it's much worse today because of the federal policies that began in the New Deal when the government first got involved in housing. May I take the privilege for a minute of responding to something that Robert said?
Okay.
He described the experience of his parents.
Robert Plenow, you're talking about now.
The
Yeah.
president
Of the federal bar.
Of the federal bar, yes. I can see you in the back. And you ended your comment by saying that the government was not involved in the experiences that you talked about. And I want to beg to differ. Unless your parents were the first African Americans ever to want to go to college in the state of Washington, the University of Washington which is obligated under the 14th Amendment not to discriminate, was involved in the fact that your parents were the very first African Americans to be there. When your parents sought housing, sought to rent apartments, if the buildings were mortgaged by banks that were regulated, if there was savings and loans either by the state of Washington or federal banks regulated by the federal government, those institutions were violating the 5th or the 14th Amendments in creating that segregated pattern. So the government is deeply involved in this system that we've created, not just in public housing, but in all of the institutions that your parents interacted with. I'll just say give you one little anecdote. At the time, your parents, I think, when your parents sought that apartment, the chairman of the Federal Reserve Board was William McChesney Martin. And he was asked in a congressional hearing, I believe, why, when they regulated banks, they didn't examine whether they were engaged in racial discrimination. And he said, well, racial discrimination is economically inefficient. And so if there was any racial discrimination, the market would have eliminated it. And therefore, the Federal Reserve Bank does not have to investigate whether banks are discriminating. So that was the environment that we were operating in the mid-20th century. And, the government was deeply involved.
But when we say New Deal, and we say Franklin Roosevelt, we think of a progressive thinker. Now, when we go back to the early 20th century, a lot of people may not have realized it till fairly recently, but the federal government civil service was fully integrated until President Woodrow Wilson declared, no, we're not going to hire African American or blacks or Negroes or whatever he was calling them in those days. And he, when he was president of Princeton, had also established the policy of no black people admitted to Princeton. So there we can point the finger at somebody. And we can point the finger at FDR for the Japanese internment, which is a horrible chapter in American history too. But where did this New Deal come from? Who was the architect of saying we want to do it this way, not this way?
Well, we frequently think, as I indicated a minute ago, of segregation as something that happened in the South. The excuse that is popularly given for that is that the New Deal required the votes of Dixiecrats to support its economic program, and therefore the one compromise that they made was not to touch segregation in the South. But it went much farther than that. The Democratic Party at that time, North and South, was a segregationist party. Republicans were much more liberal on this grounds, not sufficiently so than the Democrats. You know, in 1932, most African Americans voted for Herbert Hoover. They didn't switch until 1936 when the New Deal was flourishing. And they did so because segregated benefits were better than no benefits at all. And so the African Americans became loyal to the Democratic Party as a result of the New Deal's economic programs. But they were always segregated. Cleveland, that I described a minute ago, there was no requirement on the part of the Roosevelt administration to segregate public housing in Cleveland in order to pacify the Southern Democrats. They wouldn't have cared what the government did in Cleveland. They didn't care that there were integrated schools in the South. What they cared about is that the South be preserved as a segregated society. So when the government imposed all of these policies in the North, it was doing so because the orientation of the entire Democratic Party was segregationist. One of Roosevelt's closest advisors was someone named James F. Burns. He was a senator from South Carolina. At that time, there was lots of, as you may know if you know your history, there was lots of interaction between the executive and legislative branches.
You mean back room talking?
Well,
deals,
not so
yeah.
background.
Yeah.
Felix Frankfurter was well known as the most important advisor while he was on the court. He was the most important advisor to FDR. But Jimmy Burns was a chief advisor to Roosevelt. He was the leading opponent in the Senate. He was a senator from South Carolina, leading opponent in the Senate. The only civil rights bill to be even considered in that period, which was an anti-lynching bill. And this close advisor of Roosevelt's, Jimmy Burns, got up on the floor of the Senate and said that if this anti-lynching bill was passed, there would be massive rapes of white women by black men in the South, and lynching was necessary to control that. Following that speech, Roosevelt appointed him to the Supreme Court. And he served on the court for only a year, and then Roosevelt removed him to be the czar of the domestic economy during World War II. Now, if Jimmy Burns had remained on the court and not been removed by Roosevelt to be the economic czar of the country, there would have been no ground for support of education. Certainly no unanimous vote in ground for support of education. And maybe if unanimity was required by Earl Warren to make that decision, there would have been no decision at all. So the Roosevelt administration was a segregationist administration, North and South. And it wasn't only because of pacifying the Democrats, although that was certainly a part of it.
That's kind of a shocking thing for a lot of us to hear about Franklin Delano Roosevelt, but certainly the evidence is there. You also decided at some point in your life, Richard, not to go to law school. Did you do that so you would feel free to criticize the U.S. Supreme Court and Chief Justice Roberts, or was that just something that evolved later?
I don't know if Chief Justice Roberts was even born when I decided not to go to law school. I don't think that was a motivation.
January 27, 1955 is his date of birth, if you're interested. And why does Lasnik know that? Because I was born January 27, 1951. And
I graduated from college in 1963, so what was he, 8 years old? I wasn't following it at that time.
Yeah, but you know, you have been very critical of the U.S. Supreme Court cases in these areas because you feel that our country was at a certain turning point after the Civil War, the passage of the 13th, 14th Amendments, and the Civil Rights Acts of 1866, which could have created the society that our founding fathers really envisioned. It couldn't get there in 1787, but the idea of all people being created equal and full rights for all citizens was there for the taking until the country didn't go that route. And part of the reason it didn't go that route is, in your analysis, weakness on the U.S. Supreme Court.
Sure, that is my view. I've, as you mentioned, co-authored with my daughter a new book, follow-up to The Color of Law, called Just Action. And in that new book, there's a chapter in which I recount, case by case, the role of the Supreme Court in creating and maintaining segregation in the society. And I conclude, as you mentioned, that if it were not for the Supreme Court, you would have a racially egalitarian society. The 13th Amendment was adopted in 1865. It not only abolished slavery, but Section 2 of that amendment authorized Congress to enforce it by appropriate legislation, including abolishing any of the vestiges of slavery, what lawyers and judges now call the badges and incidents of slavery. And in 1866, Congress passed a Civil Rights Act that prohibited not only government discrimination, but private discrimination of any kind. It prohibited any discrimination in the sale and rental of property. It prohibited discrimination in the private sector generally. The Congress was a little bit of, Andrew Johnson vetoed the bill. Congress overrode his veto. But Congress was a little bit afraid that maybe that was going too far. So it wrote the 14th Amendment to incorporate the provisions of the 1866 Civil Rights Act. So this notion that there was no racial motivation behind the 14th Amendment promulgated by today's justices is utter nonsense. Congress then, following the 14th Amendment, passed another law, the Enforcement Act, which again reiterated the provisions of the 1866 law. Well, I could go on and on with these cases, but in 1968, 102 years after the Civil Rights Act was passed, prohibiting all forms of discrimination in the private sector as well as public, and in that intervening 102 years, the government enforced, as I described in utero, segregation throughout this society, particularly in neighborhoods. In 1968, I'm paraphrasing,
sure.
I'm not quoting, the Supreme Court said, whoops, we were wrong in 1866. That was really an appropriate law under the 13th Amendment. But the Supreme Court today takes the position that let bygones be bygones, and there is no possible remedy for the actions that were taken in those intervening 102 years. In our new book, Just Action, we talk about remedies and the things that we should be doing, and if necessary, find the ways to evade Supreme Court prohibition, or if necessary, create a record so that someday, just as in Brown, we relied on the dissents of Justice John Marshall Harlan, someday we can rely on dissents and appellate court decisions that the Supreme Court may not approve to create a new possibility of racial equality.
I want people, 95% of you are lawyers in this room, but when The Color of Law came out in 2017, it was a shocker to people. We knew that there was housing segregation. We assumed that some of it was zoning, some of it was just racist tendencies in different communities. Some of it was trying to defend property values, but we didn't realize how much of it was government policy. And the book that Richard's talking about, Just Action, which is the real reason we're here today to talk about the book, is the follow-up to that is, oh my gosh, this was terrible. It's not enough to just acknowledge that it happened. We have to find ways to remedy the impact. And Richard, you give statistics about white income levels and black income levels, white wealth and black wealth, that explains the lingering effect here. And would you go into a little bit about that?
Sure. One of the most powerful policies that the federal government followed in the New Deal and then in the Fair Deal of President Truman was a program to suburbanize the entire white population in single-family homes in all white suburbs. As I described before when I talked about the Cleveland example, whites and African Americans were living in urban areas prior to that time. We weren't a suburban country. The only people living in suburbs were very affluent people. The reason was we were a manufacturing economy. Factories needed to be located before the ports and railroad terminals to get their parts, ship their final products. So both black and white workers, as well as the employees of banks and insurance companies that were serving those factories, had to be located relatively accessible to these downtown factories. Well, the federal government, the Federal Housing Administration in particular, embarked on a program to suburbanize the white population of single-family homes in all white suburbs and prohibit African Americans from following them in this program. The example I used in The Color of Law was Levittown, east of New York City, but they exist here, the suburbs that were created by Boeing and other developers here in the Seattle area. Levittown was 17,000 homes in one place, east of New York City. It was a crazy idea. As I said, we weren't a suburban country at that time. The Levitt was a bigot, said he wouldn't sell a home to an African American if he had the choice, but he didn't have a choice because no bank would be crazy enough to lend him money to build such a speculative project, 17,000 homes in a place that nobody was going to want to live. The only way that Levitt could gain the money to buy the land and build the housing was by going to the Federal Housing Administration and then the Veterans Administration as well, as it ramped up, request a federal bank guarantee for his loans. And in order to get that, he had to make a commitment to the Federal Housing Administration and Veterans Administration never to sell a home to an African American. This was not the action of rogue bureaucrats. This was written federal policy. The Federal Housing Administration had a manual that was distributed to appraisers all over the country, whose job it was to evaluate the applications of developers who wanted to build these suburban projects that the FHA was prodding them to build. The manual said you could not get a federal bank guarantee for a project that was going to sell homes to African Americans. The manual went so far as to say that you couldn't even recommend for a federal bank guarantee a loan to a developer of an all-white project if it was going to be located near where African Americans were living, because in the words of the manual, that would run the risk of infiltration by inharmonious racial groups. This was what the federal policy manual said. In the previous book, The Color of Law, I have a photograph of a 6-foot-high, half-mile-long concrete wall alongside a FHA financed project in Detroit, a white project, that the Federal Housing Administration required the builder to construct before it would guarantee his loan to separate this project from nearby African American neighborhood. Well, those homes at the time, FHA financed homes. My parents bought one, and not Levittown, but in 1939, before Levittown, bought one for $5,000. Those homes sold at the time, well, for my parents, $5,000. At Levittown, it was $8,000. In today's money, that's about $100,000, maybe $110,000. Account for inflation in the last couple of years. Those homes, not in the Boeing developments here outside Seattle or anywhere else in Levittown, anywhere else in the country, no longer sell for $100,000. Maybe you know of some examples that they do, but I don't know of them. They sell for $200,000, $300,000, $400,000. In the area where I now live in Berkeley, California, they're $1 million, $2 million or more. The white families, returning war veterans, who were subsidized by the federal government with FHA loans, VA loans, requiring no down payment, but did not expect to get rich by buying these homes. They needed a place to live. There was a housing shortage. There was no housing constructed in the Depression to speak of. During World War II, it was unlawful to use construction materials for civilian purposes, and enormous housing shortage. They were looking for a place to live. They didn't think they were going to get rich, but they did. They gained wealth from the appreciation and the value of their homes. They used that wealth to send their children to college, take care of temporary emergencies, maybe medical emergencies or temporary unemployment. They used it to subsidize their retirements. And they used it to bequeath wealth to their children and grandchildren, who then had down payments for their own homes.
And so the impact today is African American income might be 2/3 of white people, but African American wealth is more like 20%.
Much less than that.
Or less.
That's the high. I've never heard an estimate that high.
Okay.
The highest estimate I've ever heard was, it's very hard to know because,
Sure.
well, people report their incomes to the IRS. There's no standardized way of, that you have to worry that you count the value of an automobile in wealth that's going to depreciate and the value of a home that's going to appreciate. But most estimates are around 2, 3, 4, 5% really of white wealth, and that enormous disparity. You'd think that if there's a 60%, 2/3%, say, income ratio, it could be that same ratio for wealth. People could save the same amount of money for the same incomes. But that enormous disparity between a 5% wealth ratio and a 60% wealth income ratio is entirely attributable to unconstitutional as well as unlawful federal policy practice in the mid-20th century. And it underlies much of the inequality we know today in this society. It's not just housing. The fact that African Americans are locked out of highly resourced neighborhoods is what explains the achievement gap in schools. It explains health disparities between blacks and whites. It explains the interactions between police and young men. When you concentrate the most disadvantaged men in neighborhoods that are poorly resourced, it's inevitable that if they have no access to good jobs or schools that aren't overwhelmed by the social and economic problems of their children, that the police are going to engage in confrontations with them. And let me add one more thing.
Sure.
That wealth gap that locks African Americans and their descendants out of well-resourced neighborhoods is a big contributor to the threats to our democracy today. We are a deeply polarized society. It largely tracks racial lines. We all know that. It's not explicitly racial, it largely tracks racial lines. And how can we ever expect to preserve this democracy, to develop the common national identity that's necessary to preserve this democracy, if African Americans and whites live so far from each other, that we have no ability to understand each other, no ability to empathize with each other? It's inconceivable we can overcome that in this segregated, really an apartheid society.
Well, that's pretty grim. Let's move on to some of the ways to try to remedy things, then we'll go back to some of the legal issues. Tell us about the Washington State Covenant Home Ownership Act and where that stands and what its hope is for remedying things in the state of Washington.
Well, Washington State is very courageous and has enacted a law that I'm sure I don't need to tell you about it. Most of you probably know about it.
I bet that we don't.
How many of you know about the Covenant Home Ownership Act? Oh, all right, okay. Not everybody.
Not even half, yeah.
Okay. Washington State has passed the Covenant Home Ownership Act, which identifies racially restrictive deed clauses that were supported by the state of Washington. The act doesn't attribute it to the federal government. I should have mentioned earlier that the FHA and VA also required Levitt to place a clause in the deed of every home prohibiting resale to African Americans or rentals to African Americans. Throughout there was a volunteer group, I think 5,000 people, who went through the deed records in Washington State to identify restrictive covenants. These deed clauses that say the home must in perpetuity be for whites only, and they exist throughout all of the suburbs of Washington, in the city, within the city limits as well. And on the basis of that research, identifying the pervasive state-supported covenants, and they were state-supported, state courts evicted African Americans if a white homeowner was daring enough to sell a home to an African American, and frequently they were, because African Americans pay higher prices than whites for homes in all white neighborhoods, simply because their supply of homes was so restricted. They had so few choices that if a white homeowner was willing to sell a home to an African American, the African American family would pay more than a white family would for that home. So there was a lot of breakage of these attempts to break it. That's how, that's how the inner ring suburbs began to become diverse. There's a whole story about that. I won't go into it now. White flight that left and so forth once this began, and the speculation of blockbusters. Some of you may know that term, real estate agents who exploited this to scare whites from leaving. Let me add, real estate agents who were licensed by the state of Washington who were doing this, in case anybody thinks this is private activity. But state courts would evict African Americans from homes that they had purchased that were restricted by these covenants. Well, on the basis of this research, the legislature here in Washington passed something called the Covenant Home Ownership Act, which creates a transfer tax of $100 on every home sale in the state, and uses that transfer tax to subsidize subsidies to African Americans who were restricted from homeowner, who were descendants of people who were restricted from home ownership opportunities as a result of these restrictive covenants. As I've indicated before, although the legislation only refers to restrictive covenants, there were many state of Washington policies that contributed to the exclusion of African Americans from home ownership opportunities.
Policies upheld by the Washington State Supreme Court going back decades ago. But the law actually calls for a study to analyze this issue. I don't think it puts into effect who gets what or how much they get, does it at this point?
I don't know. I think it provides for subsidies. It just the study is to identify the actual regulations and have the procedures to go, but it doesn't simply. It's not silent on the fact that remedies are necessary from this $100 transfer tax.
Sure, but who gets it and how much they get is still an open issue, right? And you know, $100 in a sale of a $2 million home is chump change for the people involved. But anytime the government is using money to remedy racial problems, reparations, et cetera, you're going to get some pushback. And what you're describing is a history of systemic racism in this country throughout the entire 20th century. And you know, systemic racism now can't be said in certain parts of the country, can't be taught in certain parts of the country. Are you worried that this book might be banned in certain states?
No, I'm not at all. I would encourage you not to use the term systemic racism. Call it unconstitutional and unlawful racial practices, because that's what it was. You know, systemic racism. I'm not in favor of banning it, but it's not specific.
Not banning the word, but
yeah. Right. Yeah, no, not. Well, I am in favor of banning it. But, I'm not in favor of banning the word, but it's not. It doesn't explain anything, and we have an obligation to explain the origins of the problems we face, and to attach the remedies, as the Covenant Homeownership Act does, attach the remedies to the specific unconstitutional and unlawful practices of government that created this problem. And if we start talking in specifics rather than generalization like systemic racism, which can mean anything, I think we'll be in a better position to advance remedies that are necessary.
I think that what we see at the U.S. Supreme Court, going back now to cases such as the Seattle Public Schools case, parents involved versus Seattle Public School, is you have Chief Justice Roberts saying any consideration of race as a reason to do things is immediately suspect, because the Constitution is colorblind. The teachings of Martin Luther King were all about colorblind, and let's treat everything equal. And if you bring race into the equation, you're making a terrible policy mistake. So even if you're going to say don't use systemic racism, when we talk about race, you have to have an approach that says race does matter, don't you?
Well, you bring up that case, the parents involved case of 2007. That's how I got into this. That's actually, I was, prior to that, I wasn't, I'm a writer, thank goodness, not a lawyer. I'm a writer, and I was the education columnist in the New York Times. I had a weekly column there in the days when there was a real newspaper and people were using their telephones to try to read the paper. And I was writing about education policy for a think tank in Washington. And so that's the reason I read that Supreme Court decision. I wasn't reading Supreme Court decisions as a hobby yet. And I read that decision, and I was shocked because what John Roberts said, the Chief Justice said, was that you could not have a remedy such as the School District of Washington and Louisville, Kentucky was the other one that was combined in this case. You could not have a conscious rate remedy because the schools in Seattle and Louisville were segregated. It's true. They were segregated, but they were segregated because the neighborhoods in which they were located were segregated. And the neighborhoods in which they were located were segregated. You went through it. They were segregated by private discrimination, by bigoted homeowners, by people wanting to live with each other of the same race because of economic differences between African Americans and whites. He said government had nothing to do with the segregation of Seattle, and therefore government is prohibited from remedying it. He left open the idea that if government had segregated it, maybe the decision might have been different. And I think it's, you know, I'm not criticizing anybody, I guess I have. But, yeah, when the defendants, the School District of Washington and the School District of Louisville, presented their case, they didn't go through. They didn't do an account of how government has segregated Seattle and Louisville. They acknowledged that it was simply a private matter. And so they had no basis for challenging, in my view, for challenging Roberts' view. I think that they should have, in the wake of that decision, continued the program, despite the Supreme Court decision, and when challenged, come forth with a better defense than they had done in the original case, and showed that it was actually government policy that created segregation in Seattle.
We may actually have some lawyers who worked on that case in the room, and we'll talk to them about what might have happened later. But we're at the 40-minute mark now, so I'm going to announce 3 times the verification code for the CLE. Everybody ready? That was 1. 2. All you people online are dying, I know. Okay, the letters are X, O, B, C, X, O, B, C, X, O, B, C. All capitals, okay? All right, thanks. So, you are advocating that this group of lawyers advise their clients, Seattle School District and the Louisville School District, to ignore the United States Supreme Court and go their own way, as Abraham Lincoln did with the Dred Scott decision.
Well, I'm not saying ignore it, I'm saying make a better defense. Connect it to the actual reasons that John Roberts was misinformed, to put it mildly.
But what if Roberts stayed the same way even after being given that information? Does a party have a right to ignore the U.S. Supreme Court? I mean, it doesn't say anywhere in the Constitution that the U.S. Supreme Court gets the last word.
Well, you're absolutely right. It doesn't, and as you all know, this judicial supremacy is a court-made doctrine. There's nothing in the Constitution. We're supposed to have 3 co-equal branches of government. What I write in Just Action is that every member of Congress, the president, and every judge takes an oath to uphold the Constitution. And somehow we've come to the idea in this country that the only people whose votes matter, whose oaths matter, are 5 people on the Supreme Court, and everybody else is lying when they say they're going to uphold the Constitution. And I think that we need to have restore a better balance between our 3 branches of government, and not simply defer obsequiously to every decision of the Supreme Court. The right wing doesn't do it. We would never have had Dobbs if abortion opponents had said, well, the court has spoken in Roe v. Wade. We're not going to pass any laws that defy it, that challenge it. The Casey decision was based on a decision on a legislation that was passed by the Pennsylvania state legislature and signed by the governor that defied Roe v. Wade. The Dobbs decision emerged from policies that were adopted in open defiance of the court's Casey decision. That so, you know, it's the only people who are intimidated by the Supreme Court are liberals who have a fantasy that somehow the Warren Court is going to return. We've had a Supreme Court that for all of this country's history, except for the 15 years of the Warren Court, has been denying both rights, civil rights and other elements of the Bill of Rights almost consistently, with the exception of this 15-year period, and we were seduced by it. And it's not going to return soon, if ever, and hoping that it will, and saying that the rule of law is whatever John Roberts and his 5 colleagues think, I think is not a fair interpretation of our Constitution or of our legal history.
But Richard, that's one point of view if Abraham Lincoln is president of the United States. That's a scary point of view if a certain person becomes president of the United States who is not restrained by the institutions that we tend to look to restrain an all-powerful executive. Aren't you worried that giving that much freedom to any president of the United States is going to be used in totalitarian ways?
Sure, I'm afraid of that, but I'm also aware of the history of not of letting that being the only thing we take into account. As I recounted a few minutes ago, I can go into more and more detail if you want, and I've done so in Just Action. We have a dangerously polarized and apartheid society today because of deference to the Supreme Court. And as you know, we also have an economic structure which is more unequal than any other industrialized country because of, up until 1937, the Supreme Court prohibited any kind of law, as you know, minimum wage, child labor, any kind of law that would regulate the economy. And I don't know if you know, we're still going to sing this tune of the rule of law by the Supreme Court when it considers Chevron deference in the next term. And we wind up with the inability to regulate the economy. We're in a very dangerous period, I think. You know, you can go through, it's not just race. Race is what I'm concerned with, and I described the 102-year history of the Supreme Court's record on race, but it's economics, it's campaign finance. And the notion that these are you know, neutral judges who somehow look at the Constitution each time they come into office and detect something that previous justices didn't detect, I think is silly. The Supreme Court justices come to office with policy priorities and then find excuses in the Constitution to justify it. This has certainly been the record, I think, of the current court, and it was the record of many previous courts as well.
That's pretty heavy stuff. We're lawyers and judges who take an oath to defend the Constitution, but we also agree to abide by precedent of our circuit, unless it's been overruled by the U.S. Supreme Court and by the U.S. Supreme Court. You start telling judges, not just at the U.S. Supreme Court level, but at the district court level, to go their own way, you end up with some decisions like we're seeing in some parts of the country, and you end up with judge shopping like we're seeing in some parts of the country, where people on one political perspective take the case to San Francisco or Seattle. On the other perspective, they take it to a one-judge district in Texas or in Mississippi or Louisiana. Do we really want to go down that route?
But we are going down that route. We are going down that route. And you say you take an oath to uphold the Constitution. that is given less importance in many lawyers' minds than deferring to the Supreme Court, which is not upholding the Constitution.
We may put that to a vote later with the assembled here, but you know, I've glossed over a little bit of your resume, but you've worked with some extraordinary people, both in the East Coast and in the West Coast. I know that your move from the East Coast to the West Coast was generated more by desire to be near your children than
Grandchildren.
and grandchildren. Okay, but John Powell, tell us a little bit about what it was like to work with John Powell.
Well, it was John Powell, actually, when I first started getting interested in this, said to me, we're talking now about the John Powell who heads an institute at Berkeley.
Something about openness?
Othering and Belonging Institute.
Othering and Belonging Institute. Let me just say a little sidebar on John Powell, who I had the pleasure to be on a panel with. He's an African-American scholar, and he spells his name all lowercase because he wants to convey that he's part of the world and the universe and doesn't see himself stand out at all. I mentioned this the other day to my colleague Jack Kuhnauer, who said, that's a great idea, I'm going to spell my name with all capitals. Go ahead.
Well, it was John Powell. It was John Powell when I first started getting interested in this topic. That Richard, pay attention to the 13th Amendment in the 1866 Civil Rights Act. So I'm forever indebted to him for that one sentence bit of advice that he gave me when I started looking into this.
And then at Harvard, you were greatly influenced by a man named Robert McCloskey, who was not an attorney either, but was a historian. We used to have more, I think, real historians than we do now, but also wrote a book about the U.S. Supreme Court. That's the classic text. How did Professor McCloskey influence you?
Well, as you say, I decided not to become a lawyer. Actually, I never even considered it. But I did go to college at Harvard, and he became my advisor, and his course on the Constitution was the most important course that I took. It was my favorite course. It was the one that stuck with me to this day.
So, you know, Richard, when you and I grew up in New York City, there was a bond between the Jewish community and the African-American community on civil rights that saw, you know, a lot of young Jewish boys and girls go down to the South to fight for civil rights, saw people putting their lives on the line for each other in a movement that was not that popular in certain parts of the country. And it looks to me like we've had a breakdown in that Jewish American, African American society being on the same page. And I don't want to get into the whole Israel thing or anything like that. But when you were growing up, did you sense that there was this solidarity, and you actually went overseas and came back after certain key moments in the civil rights?
Well, I don't think it's changed. I think Jews generally tend to be more liberal than other whites in this country on issues of race, even today. There is certainly a right-wing cohort in the Jewish community that doesn't share those views, but I still think it's the case. You know, every March or April, Jews hold a ceremony in which we say we were once slaves in Egypt. That's a message that sticks with many Jewish people and still influences them today. Yes, it's true. I was planning to go to graduate school and become an academic. That I did consider. And when two young Jewish men and one African American Goodman, Schwerner, and Cheney were killed. I quit graduate school and came back here and became part of the civil rights movement. So that is part of my history.
And of course, some of you know that Mississippi burning case, Mickey Schwimmer's wife at the time is Rita Bender, who's still a lawyer in Seattle at that law firm. And I know Peter Offenbecker's here back there. And, you know, Rita married Bill Bender, established a life here in Seattle, but she is a constant reminder of what that was all about. And, you know, she participated in the eventual prosecution of the killers in the Mississippi case involving that. And, you know, one of the things I'm worried about in terms of not having civic education and history education is I have some law clerks, not talking about the most recent, Yara Alvar, or the least recent, Dan Johnson, but some in between who didn't know who Judge Frank Johnson was and didn't understand what the federal courts went through post Brown versus Board of Education in trying to enforce those orders, and how Frank Johnson's parents' home was firebombed because they thought that's where he lived, and what people went through. And I worry that we're losing contact with that history of both the civil rights movement and the federal courts showing courage in enforcing certain rulings.
I agree. But, you know, and let me, referring to the comment you made before, you know, these laws that are being passed, particularly in southern states, are designed to intimidate. But if you actually read the laws, none of them prohibit the teaching of the facts about segregation and suppression of African American rights. What they do prohibit is stuff like systemic racism, and so we need teachers who will teach the facts without slogans, because slogans don't educate anybody. And if they do so, and if they are disciplined for it, again, they should be willing to be prepared to stand up to that. In Just Action, this new book, I remind people about the Scopes trial. Some of you may know what I'm talking about. In the 1920s, the state of Tennessee prohibited the teaching of evolution. A teacher named John Scopes was fired for teaching a very watered-down version of evolution, but still mentioning Darwinism. And there was a famous movie made of it with Spencer Tracy and what's it called? Inherit the Wind, I think it was called.
Yes, it was.
And he was eventually fined $1 for this crime of teaching evolution.
And the adversary to Clarence Darrow was William Jennings Bryan, who a multiple candidate for president and a true believer that when the Bible said God made the world in 7 days, that's exactly what it means. Literal, original intent interpretation. Well, it was a fascinating
the best line of the movie was he said that I'm more interested in the Rock of Ages than the Age of Rocks.
They don't make movies like that anymore. Of course, we know going forward from this day what your answer will be to, you know, who was the best interviewer you ever had. But before today, you must have done 50 or 75 different interviews, 2 with Terry Gross on Fresh Air, Ta-Nehisi Coates interviewed you. You've been all over the country. How has that gone for you when you look back on that was a surprising experience, or that was totally missed the point, or that audience was really hyped up versus that audience fell asleep on me?
Well, it's been a very rewarding experience because I meet wonderful people like you doing it. I like to say I've been every blue dot in every red state in the country. And I don't generally talk to hostile audiences that other ones who invite me. But I had, I was a fairly well-known education policy writer, so I had a lot of experience before I started talking about this in public presentation. It's been a wonderful experience. Met so many wonderful people, including Cynthia Jones.
Oh, yeah, she is up there, no
Betty
doubt
Davis.
about that. Well, you know, Roger back there who's doing these programs, maybe we'll get Richard on a Ninth Circuit panel. You know, some of you may have been at the Spokane conference, not the one in 2019, but the one in like 2005 or, yeah, I know there was one in 2019, but I'm talking about the one in 2004 or 5 when we had Sherman Alexie, the Native American writer, gave the opening remarks, and he talked about his experience as a Native American and how the only people who cared about his people's issues were federal judges. And so he was so happy to address this group. And he said 2 more things. One, he saw Sandra Day O'Connor in the front row and said, I am so much thinking about having a Harold and Maude experience with Justice O'Connor. And then 2, he said, I want to especially give a shout out to all you Reagan appointees who say, I hate these goddamn Indians, but we signed the treaty, so I have to enforce it. And, you know, there is something to be said for us hearing from those people and recognizing that, you know, judges don't always do what the judges did in Dobbs. You know, a lot of times they will say, that's not how I would vote if it were up to me. But, you know, I have to be bound by precedent. Now, I totally disagree with this concept of, you know, that case Roe was egregiously wrong. I mean, that's outrageous to me. Although I must say, I sat on a Ninth Circuit panel last year. The petitioner in this habeas case was somebody who had committed multiple murders when he was a juvenile in the Las Vegas area. He pled guilty to a life in prison recommendation to avoid a potential death penalty. A couple of years later, the Supreme Court changed the rule that you can't execute a juvenile. And he was now, 10 years after that, brought another habeas petition to try to reopen his case and go to trial. And my first question to the federal defender was, have you talked to your client about the possibility that this U.S. Supreme Court will say that decision voiding the death penalty for juveniles, which was a 5-4 decision, was egregiously wrong, and that your client might still face the death penalty going forward? And the defender was totally knocked off stride because she had never considered that such a thing could happen. But what does that mean if things are egregiously wrong, that a majority on the Supreme Court could void precedent that was 20 years old, 30 years old, 50 years old? Something to worry about. But not for you, Richard. You don't have to worry about that at all. The other thing in Just Action that really jumped out at me that I'd like you to talk about was that experience in Chicago, where you had people in the north part of Chicago, all white, and people in the south part of Chicago, all black, kind of meeting each other, exchanging points of view, and becoming a new community.
Sure. Just Action, this book, has really 2 aspects. One is it describes local policy after local policy after local policy that reinforces and sustains segregation, and how those can be redressed. And I can talk about a couple of those in a minute. But the other part of it that you're talking about, is its emphasis that there is no political will today to enact significant national policies to redress segregation. There's not even sufficient political will in most parts of the country to do it at a state level, which is why the Covenant Homeownership Act in Washington is such an amazing, wonderful step forward that perhaps others will imitate. But there is enormous potential at the local level. There were 20 million Americans who participated in Black Lives Matter demonstrations after the murder of George Floyd. They were suburban and urban. They were white and black, and other races, other ethnicities. They were rich and poor. And most of them, after the end of those demonstrations, went home. They put Black Lives Matter signs on their lawns and in their windows and did nothing further. And that's an enormous base for a reinvigorated civil rights movement to begin to redress the racial inequality that we've been talking about. But one of the challenges that we face is that because we're such a segregated society, outside of the workplace, African Americans and whites have very little contact with one another. There are very few social relationships that we have outside the workplace. We didn't used to have it even in the workplace, now we have more of it. But there are very few social relationships that we have with people of other races, of the other race. And so the first step in creating a reinvigorated civil rights movement is to create biracial communities, small groups that get to know one another. And so we'll give a few examples of people who've done that. One of them is the one you're referring to. There's a photographer in Chicago, an artist. Her name is Tanika Johnson. You can Google her. Fascinating. But she had this idea of, well, Chicago is maybe some of you know, is a grid. The map is a grid. And so it's the streets go from north to south and from east to west. And there's a 0-0 point in the downtown. And if you go north on the street, the street will have the same, the house will have the same number, 3500 North Ashland, as a street, as a house exactly as far south of the midpoint, whose address will be 3500 South Ashland. But the one on the north will be occupied by a white person, a white household, and the one in the south will be occupied by a black household. So Tanika Johnson had the idea she would take this map and fold it in half. And she called the houses with identical addresses, except from north and south, white and black, as being map twins. And she went and photographed these houses and then knocked on the doors of the people who lived in them and said, would you like to meet your map twin? And she started this, not really a formal organization, but this community of people who met their map twins. And they you know, the requirement was that they had to invite each other over to their homes for dinner and take each other on a tour of their own neighborhoods. Most of them had never been to the other side of town, except for some of the African Americans who come north to work in restaurants or hotels or other service industries. But she created a community. Now she's not an organizer, she's an artist, and she's done a number of other projects along these lines. And I am actually working with a national group that's trying to hire organizers to help groups like this take steps to redress segregation. And if there were an organizer in that community, they would have a base to begin with these map twins who found out that they had a lot in common that they never believed they would have with their map twins from the other side. There are many, many other examples like that. I talk about an example of in Winston-Salem, North Carolina, where there are 6 Presbyterian churches. 3 are all black, 3 are all white. They don't know anything about each other. They decided, the ministers of these churches decided to see if they could overcome some of the divisions in their community, and they created something called the Presbyterian Interracial Dialogue, which was a group of 40 people, rigidly required to be 20 whites and 20 African Americans. If anybody dropped out, they had to be replaced by somebody of the same race to maintain interracial balance. And they actually did wind up taking some significant action to challenge racial inequality in Winston-Salem. So there are many ways of doing this. You don't have to live in a city with a grid to meet other race households from the other part of town.
But the idea that all politics is local is really brought out here. If you're going to make change in some communities, it needs to be done on a real grassroots level, doesn't it?
Well, it needs to begin there. It needs to begin there. We're not going to have a
Right.
national, I don't think we're going to have a national reinvigorated civil rights movement without the beginnings of local activity. Because once the federal government plays the primary role in creating segregation, it's local policy that reinforces it. Can I give one example?
Sure.
This is my favorite example. It's not my daughter who's a co-author, but she has other favorite examples. But my favorite example is that the property assessment system, property tax assessment system is racially discriminatory in almost every metropolitan area of this country. African Americans pay higher property taxes relative to the value of their homes than whites do. And this is systematic across the country. And it's been documented by economists who have these giant data sets and prove it. It's a purely local issue. There are no federal tax assessors. It's all done by counties and cities. And the reasons are many. One of them is that, I don't know how it's done in Washington, but in many parts of the country, most counties and cities don't do a physical reassessment of property every year. They wait a few years. And as you probably know, property values in white neighborhoods appreciate in value faster than they do in black neighborhoods. So if you wait more than a year or two to reassess property, the assessed value of a home in a black neighborhood is going to be closer to its market value than the assessed value of a home in a white neighborhood, which is not too farther below its market value, which means that African Americans in every metropolitan area of this country are paying a higher share relative to the market value of their homes of the costs of schools, of libraries, of fire departments, and other services that are supported by the property taxes. This is a purely local issue. And a local civil rights movement, if it organized and became powerful enough, could challenge this. And there are so many of these. That's what Just Action is really about, describing all of these many local issues that can be done, can be attacked by local activists if they were serious about redressing segregation. Came together for that purpose.
And some of the communities that you would expect to take action, like the state of Washington, have. Others, like the San Francisco Bay Area, not so much, right?
Well, nothing, I don't think anything has been as forthright as the Covenant Homeowners Act in Washington. But there is progress around the country in small ways, in the San Francisco Bay Area as well. Not much, not enough, and there's not enough organized support for it. But we have many examples in the book of local groups that are taking action and making small progress that other people can learn from. Leah, my daughter, who co-authored this book, and I, mostly she, but I as well, write a frequent column on a platform called Substack that updates. You know, The Color of Law was a book of history. I could write the same book today, 6 years later, and the facts wouldn't change. It would be the same book. But Just Action is an ongoing story. People are doing these kinds of things all the time, and we're reporting on new developments in this column that hadn't happened yet when Just Action.
Now, obviously, a lot of people, after Color of Law came up to you and said, what can we do about this? What can we do about this? Was your daughter Leah one of them, or did you go to her and say, Leah, we got to do something more than just this. Can you help me write the next book?
Well, I'm an old man and I wasn't prepared to write. I thought The Color of Law was my last book. But everybody asked what could we do about it. I felt an obligation to do something else. I actually pestered Leah for several years to come work with me before she finally consented. But she was one of the people. She was inspired by the Black Lives Matter demonstrations. I got her to quit her job and work full time with me writing this new book. Somebody asked me the other day when I was we were giving a presentation of what was it like to work with my daughter. I said it was the best thing that ever happened to me in my life.
Nice.
It's been a wonderful experience. She will be speaking tomorrow at an event here in Seattle.
Seattle University, right?
Yeah.
From afternoon this year?
It's in the afternoon, yes. I don't know the name of it. But it's a big event of housing developers and affordable housing supporters that we're speaking at.
Wow, that's great. And how many times did she say to you, "Oh, Dad," and how many times did you say to her, "Listen to your father"? You don't have to answer that. So
She did
Yeah.
say that one condition of her coming to work with me is I had to stop telling bad jokes.
That's great. Cynthia, do we have questions that we're going to take from the audience, or do we have them online, or both? Okay.
How would you like?
Let's start with people here. Does anyone have a question they would like to ask Richard Rothstein? Please raise your hand. We'll start there. Stand up and belt it out.
Thank you for your comment on site. I wanted to fact check something I overheard at this gathering today that I was taken aback by, and that was that the publication of your book, A Color of Law, was opposed by the Obama administration, and it wasn't until the Trump administration that your book was published. So I'm fact checking.
Oh, no. I'm going to repeat the question because people online may not hear it. So the question was the publication of The Color of Law opposed by the Obama administration? No, there's no truth to that whatsoever. What you probably heard was that I had great difficulty getting Color of Law published because the publishing industry wasn't interested in it. Because I was told that because Obama was president, we were a post-racial society, and nobody was interested in this kind of thing anymore. But there was certainly no, first of all, the Obama administration had nothing to say about what books were and weren't published. No, the administration had nothing to do with it. It was the publishing industry that I had to fight with for a long time to get the book published.
And Chief Justice Roberts didn't try to stop it either, right? Just for the record. Another question. Yes, please stand up and belt it out.
Say a little bit more about a comment you made that the segregation has led to our current polarization. And somehow that struck me as not to test that we're polarized, we really are, but tying the polarization to segregation didn't quite ring through. As I look at it, the news about MAGA rallies, they appear to be as close to 100% white as it's possible to be, and the left side tends to seem fairly integrated. So how do you say that what causes you to say that the segregation has led to polarization, as to other things which really have led to polarization?
Well,
I'm
sorry, yeah. The question was asking me to defend my earlier statement that racial segregation has contributed to our racial polarization. And I said it largely tracks racial lines. You're right, you're correct that opponents, the MAGA Republicans and the MAGA supporters are more homogeneously white than opponents of those are homogeneously black. They're not homogeneously black. They're more whites who are in favor of simply because whites are more numerous in favor of racial justice than there are African Americans. So you're correct about that. But what I was saying was that a good part of the when MAGA, as you say, the MAGA white opponents of progress in this area, what does MAGA stand for? It means make America great again. And what they mean is make America white again. And they are threatened by, their identity is threatened by the fact that we're becoming not only a more diverse society, but we are enacting policies that advance the interests of African Americans in particular. So that's a big part of their motivation. And I think that polarization, our racial polarization, contributes to that, because people who have no contact with each other have no understanding and tolerance of each other. And one of the things we know from social psychology is that, documented by social psychologists starting in the 1950s, is that interracial contact, if it's interracial contact of people who are socioeconomically similar, not identical, but similar, leads to greater understanding and identity. And without that, it's very difficult to develop that identity.
But Richard, do you ever get pushback from Asian American or Latin American people to say, you know, we have some of the same issues, but we were able to work around it?
Well, this is a complicated issue, and it's especially complicated here on the West Coast. The policies that I was describing that segregated this country were directed at African Americans, in large part because we were not a really fully national country at the time, and there was no non-whites east of the Mississippi, even really east of the Rocky Mountains, except for African Americans at that time. So the policymakers who were imposing segregation weren't concerned about anybody else than African Americans. But it's true that here on the West Coast, there was certainly equally unconstitutional policies imposed against Asian Americans and Hispanics. So there's certainly grounds for that kind of for remedies here as well. But it's a much less powerful impetus behind our segregation than the segregation of African Americans. And as you mentioned, it's not that the Hispanics and the Asians managed to overcome it. It's that they didn't overcome it of their own volition. They overcame it because the discrimination and hostility towards them is less than it is towards the descendants of American slaves, who were initially stereotyped as being less than human, and that thanks to the Supreme Court, that stereotype was never confronted or challenged. So, I'll give you an example. I was talking before about restrictive covenants and how courts enforce them by evicting African Americans who had purchased a home that was deeded to be only for whites. And there were occasions where, in California in particular, where a Hispanic had bought a home and neighbors had challenged it in court, and the judge ruled that the restrictive covenant, even though it named them, didn't really apply to them because Hispanics were really Caucasian and couldn't be excluded on that basis. So, and of course, it's I grew up, not grew up, I lived for a long time in a neighborhood that in Southern California, where a middle-class neighborhood, where many of the families were of Mexican origin. If it was a family where there was a Mexican origin husband and a Anglo wife, where the family had a Hispanic name, that family was the children considered Hispanic at school. If it was a white and Anglo husband and a Hispanic wife, where the family had an Anglo name, the children could identify as white easily and not be treated any differently.
Baseball player Ted Williams, for example. You have a question back there. Yes, Robert, you want to see if that microphone works?
I don't think I'll need it.
Okay.
Okay.
Hello. Hello. It does work.
It does work. Okay. Also, just shout out, as a Chicago native, that story does ring true in a lot of different ways. But my question is, you talked about this romanticization of the Warren Court, a 15-year period out of 100 years of inhumane and unconstitutional Supreme Court decisions. How do you suggest, do you have suggestions of how we get people, a lot of the time, the generation of this room, out of this idea that it must be the court at a high level that is going to institute these policies and decisions to reverse and or undo these decisions? But at this point, if they have not done so by now, they never will.
Well, you have to help me figure that out. Seriously, my only recommendation to you is you take more seriously than you do your oath to uphold the Constitution. And not define that as simply how John Roberts defines what your oath means.
Do you want to do some online questions, Cynthia? Or you want
Sure, I'll wait for the microphone and perhaps.
Sure.
Thank you. Nikki Travell with the National Fair Housing Alliance.
Oh, hi.
Thank you so much for this opportunity to join you all. Richard, can you talk a little bit about whiteness and how our nation's homeownership policies actually cemented whiteness? And I'm thinking specifically around the FHA manual, where when we talked about whites, they were ranked, with Western Europeans being at the highest level of that ranking and other Europeans being much lower. Could you talk about how our homeownership policies help to cement whiteness and what your thoughts on around whether our policies are intentionally keeping segregation because it's reinforcing this idea of whiteness?
It's not a topic I think about very much, but I will say this. In the early 20th century, the Irish and the Italians and the Jews were not considered white. And they became white as they assimilated in subsequent generations into the broader society. They weren't identifiable as they assimilated as being from a non-white group. African Americans, we have the one drop of blood rule in this country. African Americans, no matter how much they assimilate, are still identifiable as a non-white group. And I think that explains why they are singularly discriminated against. Many of the policies in the early 20th century, I'm not talking now about the New Deal, about the early 20th century of discrimination were aimed against Southern and Eastern Europeans. The decision in the mid-1920s, I forget the year, that upheld exclusionary zoning was based on what the court considered a constitutionally appropriate policy of excluding immigrants from Europe, Eastern European low-wage immigrants from Europe, from white neighborhoods. And that was the impetus between the policy, and you know the court case better than I do, I'm sure, but the policy held zoning as a means of excluding what was considered non-white groups, and that wasn't aimed at African Americans, that was aimed at Italians and Jews, and to some extent Irish.
We'll take some questions from the online questions.
One more in
Oh, we have one right there.
Yeah, I always thought that Shelley v. Kramer was a very heroic moment for the Supreme Court, and that was Fred Vinson, not Earl Warren, 1948. And Felix Frankfurter and Hugo Black, the former Klansmen appointed by FDR, were in the majority on that. So I was just wondering if you could just talk about that in relation to all the things that you've said as far as the Supreme Court in relation to racially restricted housing.
Well, yeah, what the Shelley v. Kramer decision did, as I'm sure all of you know, or most of you know, was it prohibited the courts from ordering the eviction of African Americans who had purchased homes in violation of a restricted covenant. It was a unanimous decision, 6-0. 3 justices recused themselves because they lived in homes that were restricted by deed clauses that prohibited anybody but whites from living them. But the focus I have on that decision, yes, it was a courageous decision, but there was no remedy for the years of the decision was 48 and the restrictive covenants began in about 1920. There was no remedy for the 28 years in which African Americans in particular were excluded from housing as a result of those deed clauses. And that's, Brown versus Board of Education is another example that I keep on thinking about. Brown versus Board of Education prohibited the segregation of schools because African Americans were getting an inferior education from attending segregated schools. But weren't those African Americans entitled to compensation for the fact that they had received inferior educations? We can't simply look forward when we're redressing segregation. We have to look backwards as well and remedy the unconstitutional, unlawful policies that created the inequality we have. And I think the failure of our legal system, even when it issues good decisions like Shelley, is its inability to consider how we remedy the effects of past unconstitutional, unlawful policies. Shouldn't those kids gotten compensation for an inferior education that not only affected their life trajectories, but the trajectories of their children, grandchildren?
And I would say not from the court. Maybe they should have gotten a remedy from the government or anything, but judges are not in a position to just say, okay, so every student who was in a segregated school gets a scholarship or this or that. But your point is well taken, that it's not enough to just say the Constitution does not allow this when a group of people have gone through what so many people in this country have gone through, where they were treated so badly by their governments.
Well, the NAACP that filed that case did not feel that it had the political possibility of asking for a remedy. But the court could have returned that case to the states and ordered them to come up with a remedy for the segregation of schools for the present generation.
Absolutely could have, but Richard, you also have to look at the fact that just doing what that court did, led to a movement to try to impeach Earl Warren, and the legitimacy of a court that doesn't have an army, doesn't have a police force, can't enforce its own orders. Courts have to consider they can't push the envelope too far or they will lose the support of the community there. And it was a strong message that Earl Warren sent with a unanimous Brown versus Board of Education. And I think if he had pushed it to that level, it might not have gone down as well.
Does the current court take that into consideration?
You mean me? No, that's a good point. It's a good question. Cynthia?
Yeah, we have some questions from our virtual attendees. One of them, just to be fair, had asked as the program was getting underway about the Shelley v. Kramer case and asked that to be discussed, and it has been. But one thing that he put in the chat is a reference to the PBS program owned and wanted to recommend that. Then another question came in, is there an organization that volunteer lawyers can work with to remove the racially restrictive covenants in Washington? He's interested in removing them from neighborhoods in his town.
Well, I think the state Supreme Court has ruled that they're illegal. You know, any lawyer could probably just get it done fairly quickly. I volunteer Paul Lawrence in Pacifica to do it.
I will say that for said lawyers, the University of Washington does have a project where they have people come in and look back over the deeds,
Great.
identify them, so that there is that opportunity.
Thanks, Paul. Yeah.
Okay, the next question is if you can address the significant impact of the Fair Housing Act of 1968 on the real estate practices in the United States in the context of eliminating racially predicated mortgage lending practices.
Well, the Fair Housing Act was an advance, but it's been very inadequately enforced. I'll give you one example about mortgage lending. We write about this in Just Action. You all know that getting a mortgage is based on having a good credit score. Our credit scoring system is racially discriminatory. It's not in intent, but in effect, like the tax assessment, property assessment system I talked about before. In order to get a good credit score, the credit agencies examine your past record of repaying money that you owe. If you've had a previous mortgage and you have paid your mortgage, made your mortgage payments on time, you get a good credit score. If you don't have a previous, and 40% of African Americans are homeowners, about 70% of whites are homeowners. So from the get-go, not having a record of past mortgage statement, mortgage records, as the only primary means of evaluating your creditworthiness is going to be discriminatory in effect. But why not count rents? Well, credit scoring, what if you've rented all your life and have never missed a rental payment? That doesn't help you in your credit score because rent is not considered in the credit scoring system. So African Americans, even if they are just as creditworthy as whites, are less likely to have a good credit score that's counted in getting a mortgage. The Fair Housing Act has not been enforced to require reform of that system of identifying credit. A couple of years ago, Fannie Mae, the Federal National Mortgage, is that what's called, Federal National Mortgage Association, the quasi-government agency that refinances banks that issue mortgages. Fannie Mae issued a recommendation that individual applicants for mortgages could assemble records of their rental payment and over their lifetimes and submit that for consideration. This is not something that mortgage holders have to do, previous mortgage holders have to do to really demonstrate it. But in the course of this, of issuing this statement, then they issued a press release about it, and I suspect that the PR guy who wrote this press release was probably fired. But the press release said that Fannie Mae had determined that in the previous 3 years, 17% of all of those households who've been denied mortgages because of inadequate credit records would have received them if their rental records had been counted. Now, if Fannie Mae knows that, that means that your local banks know who those 17% were that were unlawfully denied mortgages because the credit system was discriminatory and should be available for remedies. And a local civil rights group could press a local bank or credit union that's been issuing mortgages and have them identify who the people were who were denied mortgages, or offer the mortgage at a higher rate and less adequate terms because their faithful rental payments hadn't been considered in considering the creditworthiness.
We have a comment to one of the discussions that you've had that I'd like to know if either of you want to respond to. And it is, I think that it's interesting to embrace fidelity to the Constitution over fidelity to the court process, particularly in light of the court's horrendous past in abusing populations simply because they can be singled out.
Is that the what population?
It just says abusing populations. It didn't specify which populations.
You know, this country, we teach the summer course for middle school teachers and high school teachers, I say the United States of America is a country conceived in slavery and dedicated to the proposition that only certain white men were created equal. That's where we start as a country. Have we made progress since then? Yes. Do we have a hell of a long way to go? Yes. And, you know, I still believe in the rule of law. I believe in courts. I believe in a balance of power. But if I had to pick one of those three institutions to have the final word on what the Constitution means, I'm going with the court, despite its difficult record over the legislature or the president. And that's just my personal belief. Richard's going for anything but the courts.
I'm not going for anything but the courts, but I'm going for a co-equal branch of government, where the oaths of legislators and executives in the government to uphold the Constitution are taken as seriously as the oaths of judges.
But if you say co-equal, who gets the last word? I mean,
That's a difficult negotiation. But the Constitution did not give the courts the last word. This is an arrogated power that the courts have assumed, and that out of
220 years ago.
Yeah, right,
Yeah.
right.
So
Well, you know, you referred to what I write about Abraham Lincoln.
Yeah.
You know, Abraham Lincoln, in the wake of the Dred Scott decision, he was a private citizen. He was neither in Congress nor the president. But he said in his first inaugural, when he was first inaugurated as president in 1861, said, if we allow the court to decide what is constitutional and what is not constitutional, and have the final and only word about it, we will cease being a democratic society. And I think that's a very serious critique. And his recommendation was that the Dred Scott decision be ignored. And many, many legislatures in the North went ahead and ignored the Dred Scott decision, passed laws in direct violation, direct defiance of the Dred Scott decision. New York State had free African Americans could vote in New York State at the time, as they could in many places in the country. But it had a discriminatory law which required African Americans to have a higher property ownership. There was a property qualification for voting. Required African Americans to have a higher property qualification than whites. And in the wake of the Dred Scott decision, New York State abolished the discriminatory property qualification as a way of sticking it in the eye of the Supreme Court. So I don't have a formula for appointing one branch of government superior. What I'm saying is there needs to be a contest and a balance. The notion of absolute judicial supremacy, not only in the issue of race, but in many of the things that create problems in this society that we all know today, is not consistent with your oath to uphold the Constitution.
You know, we had a training from the Federal Judicial Center here about Nazi Germany and how the German legislature passed laws that were designed to say who could be a German and who could not be a German, and if your mother was Jewish versus your father was Jewish, and all these kinds of things. And I had always assumed that one of the first things that the Nazis did was get rid of all the judges and appoint fascist judges. There were 2 judges in the entire country who resigned, and everyone else was, well, the legislature passed these laws and they were signed into law by the executive, I have to enforce it. So you got to be careful now that's a country that didn't have a constitution too. But if all your judges are doing is saying, okay, the law is passed, that branch of government and this branch of government says it's so and so, I'm not sure I'd be really comfortable in that kind of country either. But Cynthia, next question. Last question, or?
So we have time for one question online and one question in the room if someone wants to think of a last question to ask. So here's the last question from online. Are you going to discuss any practical remedies, giving money, property, tax breaks, something else to a certain class of people, ways to determine who is in the receiving class and who is excluded?
I'm not, are you?
Well, we've talked about the Washington State Covenant Homeownership Act, which is one effort to do that. I've described a couple of examples of things that we talk about in Just Action, the property tax assessment system, credit scoring. There are many, many others that we've described. So I'm not going to take time to go through any others, but yes.
Read the book. Yeah.
Well, the short answer is read the book. Yeah. Do we have one last question in the room? Yes.
Yeah, well, sure. Maybe this is a good last question, I don't know. I was intrigued by your comment about looking to court dissents to maybe plant the future. And I'd like your thoughts on the Students for Fair Admission and the Katie John Braxton dissent, which featured your work prominently. So give us a message for the future based on that.
Well, I'm in favor of continuing to pursue affirmative action for African Americans in college admissions. I've never been supportive of the idea of diversity. I go back to Bakke as the big problem, not the Students for Fair Admissions as being the problem, where you had one swing justice, who resolved a 4-4 dispute between those who believed, the justices who believed that affirmative action was necessary to remedy past unconstitutional policies, and those who were opposed to it. And so he came up with this idea that although we couldn't remedy past wrongs, we could treat African Americans like oboe players and try to create a diverse college. I think there are many ways that we can continue to pursue affirmative action without what the court did was prohibit it for diversity purposes. I think there are many other reasons to pursue affirmative action, and I hope there'll be courageous college presidents and boards of trustees who will consider some of them. I'm currently writing an article that will be ready, showing that when affirmative action was practiced in the late 20th century, that there's good evidence that it produced, this is just one tiny example, there's good evidence that it produced more African American physicians who could address the healthcare crisis in this country, disparities in health outcomes, and that this is a good reason to have an affirmative action program to try to recruit more African Americans to college. It's not that they know when they apply to college that they become physicians, but there's a demonstrated effect of this. There's one African American physician for every 500 in the population, for every 1,000 rather in the population. There's one white physician for every 500 whites. That creates enormous disparities in health outcomes. So if colleges should have the ability to say their mission includes addressing this healthcare crisis. And the way they can do this is by trying to recruit more African Americans for admission. So there are many ways to challenge that decision. And it may get struck down. I guess John Marshall Harlan, the first one, was struck down.
So Richard has written the New York Times article on this that's just awaiting publication. He sent it to me as a personal favorite. Thank you. It's wonderful. So look for that on your phone or your iPad.
It's not ready yet.
Not ready yet. Okay.
You're not to distribute it either.
Thanks so much, Richard. It was really wonderful having you here.
So a thank you to Richard Rothstein again, and also a thanks to Judge Lasnik for moderating. So thank you, Judge Lasnik. And I want to thank you all again for coming today. I would ask you again to make sure you fill out your evaluations and note any future topics or any related topics that you would like our Federal Bar Association to address. And with that, have a good afternoon. Thank you.